that the echo does not take place.
Kulpreet, we also have Arpinder now.
Okay, Mr. Arpinder, good evening to you. How are you?
All well. Thank you so much.
Hi,
Okay,
Arpinder.
okay.
Hi, Mr. Advani. How are you? Long time.
Good, long time.
Hi, everyone, to all the panelists. I know we didn't
hi,
meet
everybody.
in the last session. It's good to be connected.
All right, so we're going to start now. Is everyone ready? All right. Ladies and gentlemen, good evening and welcome to today's webinar, which is the webinar on conflict of interest in arbitration. I'm speaking to you from our office of WLA in New Delhi. Greetings and welcome. My name is Kulpreet Yadav. I'm one of the co-founders of WLA. This event has been organized and presented by WLA, and it is supported by Ernst & Young. So greetings to all the panelists as well. I will first mention, first actually lay the entire agenda for all of us to know before we get into the webinar. So I will be first introducing the participants of this webinar, followed by Mr. Arpinder Singh, who will be giving the introductory remarks, which will last about 8 to 10 minutes. Mr. Arpinder Singh is the Global Markets and India Leader, Forensics and Integrity Services at EY. Then we will have a panel discussion, and we have the participants of panel discussions as well. Here with us, Mr. Hiru Advani, partner Advani and Company, Aparajita Rana, partner AZB and Partners, and we have Aman Hingorani, advocate, arbitrator and mediator, international advocacy and mediation skills trainer, author, trustee, the KNH Foundation. The event will be moderated by Mr. Yogen Vaidya, partner, Forensics and Integrity Services at Ernst & Young. Towards the end, we will take question answers. So those of you registered and logged in, I'll request you to please send your questions through the chat option, and we'll be very happy to take them in the final 15 minutes before Mr. Yogen Vaidya will close today's session. Here are the introductions of our speakers and participants today. I'll start with Mr. Arpinder Singh. Mr. Arpinder Singh is a partner and global markets and India leader with Ernst & Young, Forensics and Integrity Services. He has over 25 years of experience in global investigations, dispute advisory and corporate governance matters. He's one of the few experts in India who was previously an internal auditor, statutory auditor, financial controller, and now leads forensic investigations. He was a special invitee in the ICAI's Digital Accounting and Assurance Board 2020 and 21. We have today's moderator, Mr. Yogen Vaidya. Mr. Yogen Vaidya is a partner with Forensic and Integrity Services of EY India. He has gathered around 18 years of professional experience. He has worked on engagements involving fraud risk management, fraud investigations, financial statement fraud, anti-bribery compliance, and dispute resolution. His experience in these areas is spread across various industries. Yogen has also been a guest speaker at various conferences and workshops on topics related to fraud, corruption, and corporate governance. Then we have Mr. Hiru Advani. Mr. Hiru Advani is a highly regarded name and world authority on arbitration law, and is one of the only 2 Indian lawyers ever listed in the international who's who of commercial arbitrators. Recognized as the leading dispute resolution lawyer by the Legal 500 India and an A-list lawyer by the India Business Law Journal, Mr. Advani has been known to have a fantastic success rate in arbitrations and an enviable record of having won a large number of multi-million-dollar awards in international as well as domestic arbitration proceedings. We have Dr. Aman Hingorani with us. He's an advocate on record at the Supreme Court of India and acts as a mediator in the Supreme Court Mediation Center and the Delhi High Court Mediation and Conciliation Center. Dr. Hingorani has been appointed as an arbitrator by the Delhi High Court and the PhD Chamber of Commerce and Industries, New Delhi. Dr. Hingorani has authored the book Unraveling the Kashmir Knot, which is a Sage Publications bestseller. Dr. Hingorani is a member, Board of Mentors, Masters Executive in Mediation and AMP, Conflict Resolution, Maharashtra National Law University. We also have Ms. Aparajita Rana, Aparajita is currently a partner with AZB and Partners at its Delhi office. She is qualified to practice in India, is the Sheving India Fellow for Cybersecurity for the year 2020, and a certified information privacy professional, Europe, evidencing the global standard for advisory on EU general data protection regulation. Aparajita has over 11 years of experience in advising, beg your pardon, clients in the corporate, non-profit information technology, financial services, data protection, and e-commerce sectors. Her expertise lies in advising clients on all aspects of commercial and corporate law. A brief introduction about me. As I said in the beginning, my name is Gulpreet Yadav. I'm one of the co-founders of the World Law Alliance. I'm an ex-armed forces officer with 23 years of experience, an author of 14 books, a screenwriter, an actor, and co-founder of this entity. So with that, let's move ahead in today's webinar. So may I now invite Mr. Arpinder Singh to begin with this introductory presentation. Mr. Arpinder.
Thank you so much for that. Again, if you could share the deck. Great. So I think it's a very topical area, especially if you look at conflict of interest. Obviously, being a forensic practitioner, along with being a dispute practitioner, where I act as an expert witness, I've done many of these. Maybe not as famous as some of the others on the panel, but having done this many times and being cross-examined on conflict of interest, and the fact that I'm actually told I'm conflicted, and I always joke about it, but senior counsels who cross-examine you in India generally spend half the time trying to prove that you're not independent, and only half the time on facts. I don't know why, but Mr. Advani, I'm sure in the panel will explain why Indian lawyers are different than lawyers from outside India. But when I'm cross-examined from outside India, they ask me 2-3 questions on independence, drop it, and then move to the facts. But for some reason, yes, the arguments are much more here. Conflict of interest, being even an investigator, is very standard. In most cases, when you're investigating a conflict of interest case, the person on the other side actually says, more often than not, I wasn't aware. Number 2 is, it seems marginal. Third is, you don't have the facts, or they deny it. So the conflict of interest is a serious issue in all aspects of business, and it has an ethical issue around it. So this is why I think it's very, very critical around the panel we're going to talk about today. If you can go to the next slide. Next slide, please. Yes. So if you look at this, I only have one slide, and I'll spend my 10 minutes on this. Actually, I don't need more. What are the key principles of conflict of interest? One is independence. Are you independent as an arbitrator in giving an opinion? Because technically it's a quasi-judicial process. Whatever you give is technically written, and it's a very, very critical position you hold as an arbitrator to give a judgment. It can impact people's lives, it can have financial implications. I think sometimes it is a very serious verdict. So independence is extremely critical. Fairness, you have to be fair to both sides. You have to be objective, as they use the word. Unbiased, that means you're not biased. You're not, a lot of times I've had a few cases where I'm being cross-examined, and suddenly you find an arbitrator cross-examining you as a witness. And I'm always wondering, why is an arbitrator cross-examining me? Isn't that the counsel's job? And then I realized, that arbitrator was selected by one of the parties. So it's so obvious that it's a bias. That somehow I am the witness who's given a report, paid by technically one party, and there's an arbitrator who's cross-examining me. Then suddenly when the other witness comes on board, that arbitrator doesn't ask a single question. So it's just so obvious that it's biased. And you can sense it. In the sense they're contentious, they're asking tough questions, then what, their decision in their mind is already done. So there is no fairness. And trust me, I've been through many of these sitting on the chair. I wish I was a counsel so I could ask the questions rather than sitting on the chair being cross-examined. But obviously that's the job and role I've accepted in life. But unbiased is very, very critical. Then if you take into account the fact that disclosures, it's very important to disclose correctly. So you'll find a lot of times even in our report as an expert witness, we will disclose that, are we conflicted? Are we not conflicted? Obviously, you won't take on the role if you were conflicted, but it does become a very, very serious issue. And so disclosures are extremely critical. There's sometimes a lot of ethical cases. I've heard of many arbitration judgments going against a particular party because they have either misled on disclosures or they have lied, as simple as that. I think going forward, as disclosure becomes and discovery becomes a bigger thing in India, I think this is going to become more and more critical in the ad hoc arbitration which happen in India. I find discovery is a big area outside India. At least we spend a lot of time and effort producing information, documents, validating it from an ethical and fraud perspective. I think once that starts here, a lot of that noise will go away. But I think these are the 4 principles I thought were very, very critical in any sort of discussion and arbitration. And that's why conflict of interest becomes even more critical, because it kind of envelopes everything. Now, if you take out the key stakeholders, you have arbitrators, you have experts, you have lawyers, and then you have this third-party funding, which I believe is a growing concept. If you take arbitrators first of all, and I'm sure this will be debated in the panel by Yogen and the rest of the esteemed panel which is present today. But if you look at arbitrators having financial personal interest party, I think that's definitely a no-no, right? You would assume so. Or you disclose it and debate it, right? Number 2 is arbitrators acting as a lawyer, issued legal opinions to or for the plaintiff or defendant. Again, is something which I think the Arbitration and Conciliation Act, I think, is quite prescriptive, is my read of it. Obviously, I'm not the lawyer here. Mr. Advani and all the other lawyers can debate this in the panel. But obviously, the act is very, very clear. And I was going through, in fact, the Schedule 5, 6, and 7. And in my view, again, it's very, very clear on what is conflict and what is not conflict. Arbitrators were party to the contract under arbitration, a person having an interest in the outcome of the arbitration and having the powers to appoint a sole arbitrator, arbitrators related to each other. And in India, for some reason, everybody seems related. People talk about seven levels of gap. Somehow NAS seems like 2 or 3 levels of gaps in relationships. So I think everybody knows everybody. I live in Delhi now. I used to be in Bombay, but in Delhi, whenever you meet anybody, they know everybody. So I think that conflict of interest becomes even more serious. Experts, I think people like us, we also have a serious issue around conflict of interest, and we have to be even more robust on that. So experts who don't have sufficient qualifications, experts who are related to the plaintiff or defendant, experts who are associated with competitors. You could have an expert, for instance, in an accounting firm like us, where we're auditors of a company in one of the groups. That could be an issue. Have we done a big consulting project with the other side? Or do we have a global relationship with a particular company? Experts are privy to confidential information, so sometimes they can use it against you. Is that okay? So there are a number of areas where an expert also has to be extremely sensitive and conscious. Lawyers, the relationship of law firms with lawyers are also extremely critical. I would say that's another area which should be looked at very, very closely. If you look at third-party funders, I think that relationship between funders and law firms, I feel in India, it's a growing area. I would love it, Yogen, if the panel spent some time on third-party funding, because that's still a new thing, I feel, relatively new thing. So relationship between funders and law firms, repeat appointment of individual arbitrators in cases involving the same funder, appointment of an arbitrator by a funded party. These are all crucial points. Another thing I've always been curious, and I'll like put that as a question, maybe Yogen, for your panel, is I meet a lot of law firms who say, "Hum to ye arbitrator use karenge." So that means we will use this particular arbitrator. So they're already pretty clear which arbitrators will swing their side. So I think, is that a fairly healthy practice? Should that change over a period of time? I'll leave those questions for the panel. So over to you, Yogen.
Thanks, Arpinder. That's very, very helpful, and some of the things which really requires a lot of thinking. I think some of the points you raised very, very are important and pertinent. So as we discussed, I think Arpinder has already set the context, and let me straight get into this topic and start the discussion. So to begin with, let us talk about the evolution of the concept of conflict of interest in arbitration and how does it actually arises. So like Arpinder mentioned earlier, the conflict of interest can happen from multiple sources, like it can be from arbitrators, lawyers, experts, third-party funders, and various other standpoints. So I would like to begin with Mr. Advani. As you are a veteran in this field of arbitration, so if you can broadly describe the whole conflict of interest in arbitration.
Thank you, Yogin, and thank you, Arpinder, for your very enlightening explanations and from Arpinder's side, more questions. Let me just briefly touch upon what Arpinder said about being cross-examined by the arbitrators. There is a big difference in the way international arbitrations are run and domestic arbitrations. If you were running an international arbitration, and assuming for a moment you had experts on both sides, the first thing you would do is have the experts sit with each other and come up with some kind of memorandum. What are the issues they agree with and what are the issues they do not agree with? So then the field is clear for the counsel and for the arbitrators to understand what are the differences. In India, you will find very seldom that you'll bring the experts together and narrow down the differences in this manner. And the arbitrators, don't forget, are not experts in this field. Maybe you may have some specialist arbitrators in construction law in particular, or in finance law in particular, and most of the arbitrators are not experts. So sometimes the experts misunderstand questions from the arbitrator as being either for or one or the other party. It's frankly for the arbitrator to understand what the issue themselves are. They're just not familiar enough. I appreciate what Arpinder says. From one party is hostile and the other party is a different kind of witnesses. But if you see a fair tribunal, and there are many fair tribunals, let us not go into this impression that all the tribunals, that all the arbitrators are biased. A lot of them are totally independent, and a lot of them ask questions for their own knowledge. Counsels will generally ask experts questions about their conflicts of interest, frankly, because they aren't experts in the field. It's easier for them to deal with issues which they are familiar with rather than intricate expertise of engineering or architecture or offshore oil and gas. So they find it easier to ask expert these kind of questions. I don't think that's a general rule. It does happen sometimes in India, I do agree. But with experienced international arbitrators, it doesn't happen. Having said that, I'll leave that all aside. And let me focus on the topic before us about the experts. First and foremost, the experts have to be neutral. And equally, how do you know they're going to be neutral? Because if you look at it theoretically, here the party is saying, look, this is a field day. I can choose my own judge. I can select who I want as an arbitrator. And what better chance to have? Wherever do you get a chance to select your own judge? So the answer is the arbitrator is required to give a full disclosure. The disclosure requirements under the present Arbitration Act are very clear. The disclosure objects under the IBA guidelines are very clear, which in fact have been now codified in our law. But you have three lists. In some lists, the red list, you automatically disqualify yourself. The green list, you cannot be disqualified. And the orange list, although it's called an orange list, is the gray area. Should you be disqualified or not disqualified? The larger issue is who decides whether you'll be disqualified or not. And I think that is the weakness of the system. In our system, the arbitrator himself has to decide. You have to make an application saying, sir, I'm sorry, I've seen your disclosure list. You seem to have relationships with X party or X law firm or X experts, whoever the parties involved are. So please disqualify yourself. And there is a natural tendency for arbitrators to defend themselves and say, certainly not. I'm very neutral. I'm very good. I've done so many arbitrations. I've given so many awards. I'm not going to disqualify myself. So you are stuck with a situation where you're asking a man to be a judge in his own cause. And that is in ad hoc arbitrations, one of the weakest links is in ad hoc arbitrations is you're asking the arbitrator to judge his own cause, and that judgment normally is going to be a biased or unfair judgment. He doesn't want to lose out on the arbitration. He doesn't want to show his prejudice. So he's going to say, certainly not, I'm completely neutral and I'm there. Institutional arbitration is different because parties still do have a right to appoint an arbitrator, but the institutions have a right to confirm them. So the institutions do have say in saying, I'm sorry, that although you chose this arbitration, we have from the disclosure or for sometime in very big arbitration from the discovery we have done, he's not a fit and proper person to sit in this arbitration. Institutions will say so. I myself was a member of the SEAC court for several years. And our first debate was, I lost it the first year, won it the second year, was if he wanted to disqualify an arbitrator or a party, a challenge an arbitrator saying, look, it's very unfair. He seems to have relationships with the other party, or he's been appointed very often by this law firm or by this particular company so many times. Do we disqualify him or not? And the bigger issue for us was, should we give reasons or not? Because if as an institution we give reasons, then that's opening ourselves to courts all around the world taking up that challenge and saying that, look, the reasons given by the SEAC court are wrong or they correct itself. So the first year we decided we won't give reasons. We simply will say he's either disqualified or he's accepted. And second year, just like happens in our court, sometimes the quorum changed. And then we decided, look, why aren't we open to scrutiny? What is wrong with it? If some court takes a view we are wrong and we have not disqualified somebody who ought to be disqualified, so be it. We can have as many errors as anybody else. So we decided that we will give reasons and disclose it to the parties, and if the parties choose to go to court on it, they're free to do so. And if the court takes a different decision, that's well and good. So you have almost two different tests. One is the test of the arbitrator himself saying, should he be disqualified or not should be disqualified? Second is the disclosure. And speaking for myself, I would think it'd be more appropriate if on his disclosure, somebody wants to challenge it. The arbitral tribunal itself is not the right forum to decide whether that challenge is appropriate or not. There should be another forum, be it a court of law, be it an institution, who will take that decision. Because you don't want to then go through a whole arbitration for months on end, come up with an award, and then go to a court and say, look, but the arbitrator should have been disqualified. And one of the reasons that will come up again and again, but look, even if you disqualified him, what difference? It's a unanimous award. Two other people have also agreed with him. But that's a completely irrational way of doing things, because arbitrators ultimately influence each other. They discuss the issues before writing the award, they discuss them in depth, and one or the other arbitrator may prevail or there may be a dissenting award. So to simply say if it's a unanimous award, to go to court and say, look, this arbitrator should have been disqualified, and the court puts to you the question, but anyway, two other arbitrators have already agreed with him. So after this whole process, should we set aside the award now? Or do we want a rehearing? So we think that's important that the disclosure issue should be at the outset, and they should be decided before the arbitration takes place, and with reasons. And if those reasons can be challenged in another forum, so be it. If the arbitration is slightly delayed, so be it. But let's have a clarity on that at the very outset. So we're going to deeper into some of these questions, but these are the issues that arise, and they arise frequently when the stakes are large in international arbitrations. It is not uncommon to hire a set of detectives to go and look into the background of the arbitrator. Should I go and look into the background, see what he's done before, who he associates with? And it's now become more and more common. I don't know, Yogan, if your firm has experiences, or we have certainly experienced it, and we've certainly in many cases advised parties to do it. And we have come up with all kinds of things or situations where we don't think that it's appropriate that that arbitrator should have sat and he should have disqualified himself at the outset. And it shouldn't have been the subject matter of this kind of thing. Arbitration, and lastly, let me tell you a difference between probably two of the best known, one in the best known arbitration, one of the best known judges. One is the Chief Justice of the Singapore High Court, which is Sundaresh Menon, and the other is Gary Bond, probably the most prolific writer on international arbitration. Sundaresh Menon is absolutely very clear. He says the whole system of international arbitration is going wrong because of party-appointed arbitrators. Why can't you have institution appoint all the three arbitrators? Why leave it to disclosures, this, that, and the other? When you have a legitimate institution, just appoint all the three arbitrators. Or like our courts very frequently do, forget what you all want, we're going to appoint a sole arbitrator. Then this whole issue of disclosures and bias and all start to shed somewhat into the background, and we focus on the arbitration itself. That is some opening comments and some issues that I'm sure my co-panelists may have their own view, and we'll debate it as we go along. Thank you, Yogen.
Right, Mr. Advani. I think that's very, very thought-provoking points you have raised and challenging the most obvious, mechanisms in the whole appointment of arbitrators. I think very, very pertinent. And on your second point, what you mentioned about, yes, we also have received multiple requests on conducting background checks on various arbitrators or potential arbitrators, and also sometimes on the experts. So those kind of requests do come in, and we also do a dossier on them and provided such comments. But coming back to the topic, Mr. Advani, like you mentioned, I think going into the nuances of and elements of conflict of interest, I think it is important and pertinent that we take a look at the recent judgment which happened in the English courts. English Supreme Court passed a judgment in the Halliburton matter. So by using this as a base, if Mr. Advani, you can share your thoughts in the context of the conflict of interest.
I can. It's and to look at it in context, there are two decisions we need to look at. We need to look at the AT&T decision, which came prior to that, and then the Halliburton decision, which came subsequently. Having said that, we must focus on the fact that we were in an English court and looking at English arbitrators. That makes an enormous difference. Let me put it this way, and from an outsider's and an insider's perspective. In England, you have large chambers of counsel, going up to 50, 100, 250 chambers, 7 different QCs in a chamber, and then other counsels. Now, to somebody, it seems unreal. There'll be one of the members of the chamber appointed as counsel, and one will be an arbitrator. And you say, my God, they're from the same office. How can I have an arbitrator sitting in 7 Queens bench and a counsel selected also from 7 Queens bench? And look, they're part of the same team. What are we doing with this? And but English traditions are a little different. They've upheld that each counsel is a counsel of their own right. And therefore, it's not unusual at all what I'm saying to have counsel and arbitrators from the same chambers. So they upheld those tests. And the other thing they do is the test they apply, which again I have some differences with, is the test of a judge. If in these circumstances, should a judge disqualify himself? And my answer is that should not be the test, because the judge is selected after a long process. He's been appearing in courts for a long time. There are a number of courts, or in some cases parliamentarians, or in some cases the judicial body, who've seen the man's integrity, etc., and then appointed him as a judge. The arbitrators go through no such scrutiny. They go through reputational scrutiny globally, yes, but there is no scrutiny as to who I appoint as an arbitrator. And are we going to say to ourselves, oh, what difference? Anyway, there'll be a chairperson who's, so to speak, the dividing line between the two party-appointed arbitrators. Is he supposed to have more integrity than the others, or is it equal integrity all around? Do we expect integrity from all 3 of our arbitrators, or do we just expect that because we have a third arbitrator who will break the deadlock, the integrity is his? In my view, it is completely incorrect. All the 3 arbitrators should be of absolute integrity, and that chairman should have no higher standard of integrity. I don't think the test applied by the English court is, would a judge disqualify himself in these circumstances, should be the same test, because judges have gone through a different training, a different background, and a different selection process. In the arbitrator, there is no selection process. So I think the English courts have taken a very, very pro-arbitrator stand with a too strong a belief in the integrity of English QCs, saying that they have reputation, they have standing, they're unlikely to be biased. I'm not saying some of them don't have, they do have. But as a general rule, as a test, I think those English standards should not apply globally. And I, for one, certainly would not accept the Halliburton judgment where one of the arbitrators, the chairperson, says, yes, there was a disclosure I should have made, but I forgot. Somehow it slipped my mind. Somehow it slipped my clerk's mind. These things do happen. We understand that these things will happen. It will slip people's mind. It will split our list of whichever clients we've had, we may have forgotten. They may be innocent, but to the rest of the world, they don't look good. The award should be promptly set aside and the arbitrator should promptly disqualified. Right, you made a mistake, you pay for the mistake. It's not that you made a mistake so we should all overlook it and say you're so busy and you're such an exceedingly good counsel and you've done so many cases and you're so brilliant. So we all make mistakes. Yes, you make mistakes. Should the party pay for it or should the arbitrator pay for it? I think the arbitrator should pay for it. And I think in some jurisdiction, there was statutory rule. The arbitrator also has to return all the fees as well. Whatever he's earned in the arbitration, he has to pay back. It's not that the award is set aside so the parties are put to a lot of harassment and the arbitrator goes scot-free. The arbitrators also have a responsibility. So I must say the English test of the test whether a judge would disqualify himself or if there was a slip and this happened, we can overlook the slip because he's a highly reputed QC and he's done very well, etc. I don't think those are tests of universal application.
Sure, thanks for that, Mr. Advani. That's very, very interesting comments. So let me bring in and go over to Dr. Aman. So as a practicing lawyer and also as an arbitrator, what are your thoughts on this particular judgment?
To start with, let me thank World Law Alliance for giving me this opportunity to share my views. The way I see this particular judgment, I would divide it in two parts. One is the enunciation of the principles. I mean, the judgment I feel is remarkable for the sheer range of areas covered. And the second is the application of these principles, where I would tend to agree with Mr. Advani. If we talk about the principles involved, it has brought clarity to the UK law at least on whether it is mere good practice or a legal duty on part of the arbitrator to disclose facts or circumstances, including multiple appointments involving a common party and overlapping subject matter. And the court said, well, there is a legal duty flowing from the arbitrator's statutory duties of fairness and impartiality. Because under the Arbitration Act in the UK, there is a statutory duty on the arbitrator, as in many other jurisdictions. But what is important, particularly in context of what we've been discussing, that these duties are equally applicable to both party-appointed arbitrator or independent arbitrators. So that equation is there. As Mr. Advani pointed out, the test which has been followed by the British courts, the UK court, they formed it slightly differently. They reiterated the test of a fair-minded and informed observer, the objective observer, who would, considering all the facts, objectively conclude whether there was real possibility of a bias or not. And the court goes on to say that the failure to disclose such facts could, but not necessarily, lead to a conclusion of apparent bias. I find the judgment is also remarkable because of the way it's balanced the duty of disclosure with the duty of confidentiality. Because duty of disclosure, according to the court, does not override the duty of confidentiality. So if an arbitrator needs to disclose information, he needs the consent. The consent, of course, could be inferred. An instance could be where parties have said, let's arbitrate in accordance with these specific institutional rules. And those rules permit the arbitrator to disclose the identity, for instance, of a common party or the existence of a current past arbitration involving a common party. And this, the court also balances this with certain areas, especially areas like maritime, commodities, where multiple appointments are an accepted feature without inference of bias. So here you don't need to actually even disclose. There's no duty of disclosure. So broadly speaking, I would say the judgment, I mean, I would welcome the judgment to the extent that it has brought clarity in law. It has covered a wide range of issues. But as Mr. Dwani points out, what the judgment does is, while applying these principles of law, they seem to have more faith on the trustworthiness of a QC, that he will act bona fide. And that may, as pointed out, may not actually be universally applicable, that part, particularly when we see in many other jurisdictions. I would actually rather have hoped that the court would have referred to the IBA rules on ethics for international arbitrators of 1987. These guidelines, IBA guidelines, do supplant those ethical standards to the extent is that covered by these IBA guidelines on conflict of interest. But the rules are much broader. And I would have liked to see the court draw on them. So that's why I would say it's a mixed bag. Principles laid down, one can't really, I mean, I would readily agree with most of them, at least the way they're formulated, but not the application of it.
Sure, that's very helpful, Dr. Aman. So again, going back to the moot point, which is, the conflict of interest is basically around the circumstances which is likely to give rise to justifiable doubts as to the independence or impartiality. A disclosure has to be made. That's the fundamental principle. So obviously there are multiple questions, and I'm going back to Mr. Advani. What is the right thing to do? Whether the acceptance should be done of the appointment or to decline. Are there any limits of duty on disclosures? Is there any problem with multiple appointments? And I'll link one more question which has come from the audience. So is there any limit to the number of repeat appointments of an expert, / arbitrators? I think, to my mind, both can be looked at it from the same principle. So Mr. Advani, if you can take that part.
I think that, in fact, our Indian Arbitration Act has done a wonderful job of that. While the IBA rule, they were there where some people say that we'll accept, some people say we don't accept. They may have differences. If we're doing an international arbitration, the first thing most of the arbitrators say, will you accept the IBA rules? What happens is one side says yes and one side says no. Can the arbitrators force them to say yes, no, but we are going to adopt those rules? The answer to my mind is clearly no. I think in India, we've done a very clear-cut thing. If any party or if any law firm has appointed a arbitrator more than 3 times in 3 years, I think it is, he must simply disqualify himself. There is no orange list, should he, shouldn't he. I can simply stand up and say, you've taken more appointments and just please disqualify yourself. And I have done it in the past. The arbitrator did not disqualify himself. I went to court and he was immediately thrown out. So we try and tell them very, very politely and nicely, because ultimately they're the arbitrators and we have to work with them, saying that, look, although you haven't disclosed, in India, we also have an RTI, Right of Information Act. And now almost as a routine, especially if you're working against public sector organizations and they appoint an arbitrator, the first thing you'll do is file an RTI. How many times have you appeared with this, for this particular public sector unit? And you will get that information within 30 days. It comes very fast. It's very useful. So I think in India, we've covered some of the gray areas, made it less hazy, and said very simply, if you've been appointed more than 3 times, you simply cannot do it anymore. I think that's a good thing. And I think it's the first law in the world that's codified this. And to that extent, I'm very proud of what we've achieved in India.
So that's very helpful. Dr. Aman, your thoughts on this?
Well, you see, the the way I see it is the core principle of international arbitration is that of independence and impartiality of the arbitrator. So the minute you do repeated appointment of the arbitrator by the same party, that might result in an arbitrator being more concerned with providing good service to the appointing party rather than being impartial or independent. So that seems to be the main issue involved. But here I think we do need to distinguish between different situations. There can be a situation where an arbitrator is being appointed repeatedly by the same party, but in several unrelated arbitrations over a certain period of time, whether 3 years, 5 years, whatever it is. In this case, if the facts are distinct, the subject matter is distinct, the evidence is distinct in each of the arbitration, then the view in international practice is that there's no real, you got disqualification. And a leading case is that of Tidewater's case, where the view taken was that we would presume that the arbitrator by the same party in unrelated cases are neutral, because in each case, the arbitrator will exercise as independent arbitral function. There can be a potential conflict of interest if continued and repeated appointment with the financial benefits creates a relationship of dependence, or where arbitrator gets influence, gets knowledge of facts or other factors which are outside the record of a case, which will then influence the decision of the arbitrator. So there is a potential, but generally speaking, in these kind of cases, there's not, the general practice is to allow multiple appointments. Then there can be a set of cases where the facts or the evidence are different, but the issues are similar. An example could be investment treaty arbitrations, because many investors will file claims in the same misconduct of the state and under the same bilateral treaty. But can you really debar an arbitrator simply because he's dealt with a similar issue, though on different facts and evidence? So the same factor comes in as in the first category. It is a third category, which is more problematic, where there's repeated or multiple appointments by the same party in several cases that concern similar or the same facts, subject matter, evidence. Halliburton's case was one of those examples. So here you have, of course, you have the IBA rules, which, as Mr. Advani points out, that there's a limit of whether the arbitrators currently served or served within the past 3 years in another arbitration on a related issue involving one of the parties or the affiliate of one of the parties. So you have those rules there. But it is here that where the issue comes, because the provisions are very general. There's no explanation to the degree the 2 or more arbitration cases can be relatable. And that's the reason of the need of disclosures, etc. And that's where the whole trouble starts. So that is the problem with multiple appointments. But when we say there is a problem, we need to talk about in which category of cases there can be a problem. If we go by international practice, because at the end of the day, why do we want, what was the reason behind this multiple appointments is that, one, you respect party autonomy. Secondly, in certain kind of areas, you would want an arbitrator who is familiar with the background, the trade practices, what are the norms to be followed. And if the arbitrator is familiar with that, he'll be acting in a speedier manner than a person who's not familiar. So there's the argument of both sides of respecting party autonomy, at the same time balancing that with the need of the arbitrator being independent and impartial. So that would be my take on as far as this issue is concerned.
Sure, that's very helpful, Dr. Raman. So let me go over to Parajita now, and we'll go into the very interesting part. As typically, Parajita, some people or companies may use guerrilla techniques and try to derail the whole process and delay the proceedings. So some people really feel that this issue of conflict of interest has become a very large area of concern. So can you share your thoughts on this particular subject?
Thank you, EY and World Law Alliance, all my panelists, for inviting me to be part of this great panel. So I've been hearing with interest, of course, the comments of my seniors on the panel. And I do agree. I think specifically on the issue that you're talking about, where people try to involve maybe a conflicted lawyer or somebody who's worked with the arbitrator previously, or maybe they have a previous relationship. In India, I think, at least in the law firm that I represent, I haven't really seen examples of, we don't really provide arbitrator for disputes. And I think this is the practice you will notice in most larger law firms. But of course, there are boutique law firms and offices where you will see that there is an arbitrator on the panel, and they also have lawyers who work as counsel on the same matter. So I think there has been attempts by parties to perhaps involve a new lawyer at the last minute, which kind of adds to the conflict in an ongoing proceeding. Because anyways, the requirement is for an arbitrator to have a continuing obligation to disclose. But internationally, I think what we've seen is that these kind of practices are frowned upon. In fact, there are many arbitral tribunals wherein they have rules that if you try to create a conflict of interest at the last minute, which has the possibility of jeopardizing the proceedings or adding to delay, then they can bring a stop to it. So I think trying some guerrilla techniques where you try to change counsel at the last minute, or you try to involve somebody who perhaps has some connection to the arbitrator just to jeopardize the efficacy of the proceedings. In India, I'm sure people try that, but we don't have anything specific under the Arbitration Act that prohibits this practice. But we can take guidance from what's happening internationally. It's definitely frowned upon, and this is not a strategic tool that you can really use to buy time in your arbitration proceedings. So I think I agree with the panelists to the extent that while conflict of interest is, of course, an important issue, currently, unfortunately, the law is at stage that we have to really rely on the judgment of the arbitrator. If he feels that he's in a position to act without bias and he needs to made all the necessary disclosures, unfortunately, the process such is that we have to really rely on his judgment, unless, of course, it's proven otherwise. And whatever disclosures have to be made or whatever compliances have to be done with conflict of interest, it has to be ultimately to ensure that the arbitration happens in a swift manner. And that remains, I think, the primary objective of commercial arbitrations.
Very, very helpful and relevant comments, Aparajita. So just a follow-up question on that, as you are part of a very large law firm, I think this mechanism of how typically you handle the conflicts, so conflict for lawyers who are involved in arbitration. So as a large law firm which grows larger and new partners keep coming in, there are potential conflicts in situations where there is some sort of advice is given. So in your experience in this large law firm, how you come across and handle situation of conflicts?
You're not audible.
Can you hear me?
Yes.
Yeah,
yes.
now.
Sorry. So as I was saying, since I haven't really seen a practice of us providing arbitrators for proceedings, I'm not going to talk about that example. But generally speaking, as Mr. Advani and Hingorani had also talked about, under Indian law, it's not an issue, and even internationally, wherein simply because you solicited advice from a particular arbitrator, let's say I worked in a previous law firm and I have a pre-existing relationship with an arbitrator purely in an advisory capacity. I regularly consult him. It's common practice, as we all know in India, for law firm counsel like myself to work with retired judges, and all of us have our favorites because they get familiar with the client's business and the issues at hand. So simply because you have solicited advice, that is not something that immediately results in a conflict. I think the international standard, which has also been replicated in India, is that there needs to be a proximity in terms of between the counsel and the arbitrator. And more importantly than that proximity, the proximity is actually required to be between the client and the arbitrator. Because if I am actually a briefing counsel and I speak to an arbitrator, for an advisory matter, I'm not the one who's really, you're not supposed to see whether I have a conflict. I'm ultimately representing the client. So, so I think the practice that we have to deploy in this is that I don't think it's necessary if you have simply worked with someone. Even IBA talks about the similar guidance, unless, of course, you have appointed an arbitrator. I think the scenario that we talked about earlier, if, a lawyer has regularly, I think on more than 3 occasions in the last 3 years, you have appointed that arbitrator in proceedings, then in that case, there are prohibition requirements that you have to decline. The arbitrator would have to decline that mandate. But in advisory situations, I haven't really seen it resulting in a conflict, purely because I don't think usually it satisfies the proximity test.
Right, very interesting. With that, let's come to an important point, which I think Arpinder raised earlier on the whole third-party, funding. So obviously, this issue of conflict of interest gets very, very murkier when it comes to this topic of third-party funding. So, while this is obviously a new, topic, what does that mean in terms of third-party funding? So, are there any specific pointers which one needs to really look at? So, Mr. Advani, if you can share your thoughts on that.
Okay, if I may briefly just explain to the audience what is third-party funding. Basically, there are a number of funds which have grown all over the world, which simply provide all the funding for the litigation. International arbitration has become expensive, both from the point of view of lawyers, experts, the arbitrators themselves. Spending $2 million on an arbitration is not unusual and may just be, in fact, on the much lower side. So if a party can't afford the funding, or if he chooses that he does not want to spend endless amounts of money on 40 different arbitrations that they're carrying on over the world, they go to a third-party funder and say, will you fund all this? And we'll give you a share of the winnings. And unfortunately, it's morphing into much more than that. That it started that way, originally with parties who could not afford. Now big parties, global parties say 25% or 30% of all our arbitrations are going to be off our books. We'll do it through third-party funders. The third-party funders have grown in sophistication. They're going to big law firms and saying, look, we have a lot of money. So, and you since obviously do a lot of dispute work, why don't we allocate $200 or $300 million to your arbitrations so that if you recommend them, we will take them on and go. And a lot of the international arbitrators have originally come from large law firms or are part of a law firm even today. So if the third-party funders are very closely linked to the big law firms and say we've allocated $200-300 million for you, is there going to be a tendency to favor that law firm? The answer is yes and no. Obviously, it does depend on the arbitrator. Should there be rules about it? Definitely. Now, what are the rules you can make about it? Because some jurisdictions, you are forced to disclose when you have third-party funding from the very start. Just for example, the most recent one and popular one in India is Singapore. Singapore says that now if you take third-party funding, you must disclose the funding. If you're a Singapore lawyer, if you're a lawyer from India like Mr. Hingorani or myself, and we have third-party funding, then we don't have to disclose it. But the idea of disclosure is a very good idea, because then if the arbitrator somehow or the other is involved with the third funder, he's advised the funder in some manner, or is involved with a large law firm which has 6 different cases, the third-party funder going in, it seems only proper that he ought to stand down, as there's almost a financial interest tied there. More so where people can fund in all different manners. You can have contingency fee arrangements, a law firm within a contingency fee arrangement. If that law firm wins, they're going to get a very large funding. You have conditional fee arrangements where if you do fund, the law firm will give you only part of the small funding, but if you win, you get a lot more of the funding. So there is a serious problem, particularly when the third-party funders are funding very large law firms. Do they, in fact, at some point in time, have an indirect interest in the loss or the winning of their arbitration? They may not really have, because the funds themselves are now grown so big, so that a few $1 million here or there may not impact them globally, but from an outside perception, it definitely does. If the other law firm has a kitty of $200 million that he can fund, and one of the arbitrators or somehow or the other is connected with that law firm, not for the funded arbitration, but in some manner or the other, does he have a vested financial interest? And what we always say, let's err on the side of caution. It may be being too cautious, but at the ultimate, people's justice and future is at stake. So it's better to be cautious. If the arbitrator has any link whatsoever, directly, indirectly, through his law firm office in Bolivia, although he's sitting in Singapore, should he stand down? I think the wiser counsel is yes, that the arbitrator must stand down. If there's any linkage whatsoever, indirectly, it's not going to be directly, indirectly to a third-party funder, he ought to stand down. There's a small disadvantage in all this disclosure because you create an impression on the arbitrators. The arbitrator now knows, as probably another law firm has gone through this case, found it a very strong case, recommended to the party, recommended to third-party funder, take third-party funding. So the arbitrator that now said there are about 6 different opinions on this case, and all have found that this case is a very good case to win. That's why they're being funded. So does that also influence the arbitrators emotionally, intelligently, saying that, look, it's been examined so closely, obviously there's a strong case to be made out. So does it? So whether you should disclose or not has been a matter of debate in some jurisdictions. More and more jurisdictions have now come to the conclusion, yes, disclosure is a must. And the reason they've done that is so that if an arbitrator in any way is indirectly conflicted, please stand down. So I think that that has now become the international norm. Of course, in India, third-party funding is it's a gray area whether it's allowed or not allowed. The Supreme Court said it's allowed, but there are no set of ethical rules, there are no set of regulations. So obviously a certain amount of third-party funding goes on. I can say that from some experience. It has gone on, and but there's no disclosure. And I think that's a big gap. There should be disclosures. It should be mandatory disclosures. And if the arbitrator in the most indirect and slightest way is connected to a fund or a law firm that is connected to the fund, then it's only proper that he stands down.
Absolutely. I think the way some of these funds, etc., are structured, it's very complicated. So I think a more thorough, more comprehensive check will have to be carried out when the appointment or when the third-party funders are brought in. Very interesting comments, Mr. Advani. So with that, I think we spoke a lot about looking at the conflicts, etc., at the beginning. So I'll ask one question to Dr. Aman about if during the process of the arbitration, the arbitrator becomes interested in one of the parties to be arbitrated. If the arbitrator's relative, for instance, gets connected with business with one of the parties, is the arbitrator expected to quit at that point?
In my view, yes, because there's sufficient guidance in the IBA guidelines that the impartiality and the independence of the arbitrators to continue right till the award is delivered or the proceedings have otherwise been finally terminated. So if during the process something crops up, the arbitrator must step down. I mean, the IBA guidelines, the red list, Mr. Advani talked about, that has 2 parts. Some of them are non-waivable circumstances or situations. Some of them can be waived by the parties. So in fact, the non-waivable circumstance includes that the arbitrator cannot really have a present business relationship with the party or cannot have a significant financial interest in one of the parties or in the outcome of the case. Whereas a waivable red list talks about a close family member of the arbitrator having a significant financial interest in one of the parties or an affiliate of one of the parties, or having interest in the outcome of the dispute. So that distinctions are there, what can be waived, what cannot be waived. As far as India is concerned, we are even more liberal. We do have, with the 2016 amendment of the Arbitration Act, the distinction between an arbitrator who is ineligible to be an arbitrator, as opposed to a reasonable doubt being there as to his impartiality. And we have in the 7th schedule the list of situations which render that person ineligible, and these include both the instances I've given of the non-waivable and waivable situations on the red list. But we also have a proviso to this to section 12.5 of the Arbitration Act, which says that once a dispute has arisen, the parties can, with express agreement in writing, waive off the applicability. So even for what is a non-waivable red list, it may be waived off as far as India is concerned. So we are slightly more liberal in that. But here, where I would again draw on is on the ethical standards. One is a legal duty, disclosures, etc. The other, the ethical standards, going back to the 87 rules, which need to be strengthened, in my view, particularly in view of the later developments of third-party funding, etc. We need to have something more potent than an arbitrator's own notion of fair play or discretion as to whether he is disqualified or qualified to do that arbitration. So all this discussion in context of conflict of interest, disclosure, etc., has to be seen in light of what are the mechanisms, effective mechanisms in place to ensure ethical standards being followed by arbitrators or accountability. So that, in my view, would actually be a broader issue, of course, subject matter of another debate, but a broader issue that needs to be looked at.
Absolutely, Dr. Raman. I think all the comments are very, very relevant and pertinent. Mr. Advani, Dr. Raman, and Aparajita. So clearly, key takeaways in this complex world of opportunities. I clearly see it. Changes are happening, rapidly and in high proportion. And more comprehensive approach in handling this whole conflict clearance is to be adopted before any appointment of arbitrators or experts or any third-party funders. A more exhaustive conflict check, it needs to be carried out, and then sufficient disclosures, as rightly said by all the panelists, has to be done, and wherever it requires, it has to be penned down. And right at the start, it has to happen rather than giving any rise to any controversy or giving any opportunity to any counterparty to derail the entire proceedings. So with that, I thank all the esteemed panelists for such an enlightening session on this very important and sensitive topic of conflict of interest in arbitration. Thanks, WLA, for the session. Thank you all. Kulpreet, back to you.
Yeah, thank you again. Thank you very much. And thank you to all the panelists. It was a very, very exciting and very engaging discussion. And lots of takeaways, insights, and explanation of key areas of concern. I thank each one of you who have made this possible. And we will, of course, be sharing this online as well, the entire discussion. Please feel free. We will share the links to share it with your friends and followers. And with that, does anyone have any questions?
I covered that, Kulpreet.
Yeah. So thank you very much, and it's goodbye from WLA. Look forward to seeing you again. Thank you and bye bye.
Thank you, everybody. Thank you, Advani.
Thank you.